Yes, Mr. James.
Thank you, Madam President. I go to the grounds, grounds one and two, and can I just make preliminary point that relates to both in connection with the debate your lordships will have seen referred to in Mr. Justice Jay's decision I referred to before the luncheon adjournment about reasonable or worst case scenario and its applicability, and it was said, well, it only, I think Mr. Elvin made submission, Mr. Justice Sullivan's reliance on it in ex parte Chew, environmental impact assessment. Can I just give you, it's in our skeleton, I'll just give you the references to why we say it's integral to the precautionary principle. Your lordships will see in Annex 4 of the communique from the Commission on the precautionary principle, which is in Authorities Bundle, tab 41, 1294. I'm not getting. Your lordships can go to it.
Yeah. So where are we in that? Annex 4, you said?
It's Annex 4 of the Commission's communique, which is in the Authorities Bundle, which will be in the latter part at
I'm struggling to find
41.
Annex 4 at the moment.
Tab 41.
Annex 4?
Annex 3. Sorry, my room of numerals.
There isn't a fourth annex.
There isn't a fourth annex. No, that's
right. Annex 3, yes.
Annex 3. We set it out in the skeleton, but basically it says when available data is inadequate or non-conclusive, a prudent and cautious approach to environmental protection could be to opt for a worst case hypothesis where when such hypotheses are accumulated, this will lead to an exaggeration of the real risk. So it's pointing out if you use too many worst cases, but it endorses what we say is part of precautionary principle worst case scenario. It's not which is and we've given the reference to an academic text by Van Kalster and Renz, which your lordships have at the Authorities Bundle, tab 41, and there Authorities Bundle, tab 41, and there
that is tab 41 we were looking at.
I'm sorry, tab 43, my lord. Sorry, tab 43. Just one second. And your lordship will see the second paragraph, where no exact prediction is possible. It's recommended to apply precautionary principle and take into account the effects of worst case scenario, and they cross-refer to the to the guidance. So the second point say, well, if there is reasonable scientific doubt over the data in an AA, then there must be reasonable scientific doubt of the results of that assessment, and the only way there is to look to a worst case scenario.
Sorry, tab 43, just to be clear what it is, this is an academic text.
Yes, it's in, I'll read it out, it's in the index, it's EU Environmental Law. It's the ELGA European Law Series 2017. And the authors are Van Kalster, V-A-N-C-A-L-S-T-R, and then Leonie, L-E-O-N-I-E, Renz, R-E-I-N-S.
Right, and has it been, in fact, been referred to by any?
Not that we're aware of. It hasn't got any particular judicial endorsement.
No, right, okay.
Otherwise, we would rely on that. As preferable, of course, my lord. Not that we're aware of.
No.
I can't say, but we're not saying it's been judicially endorsed and it has a status. No, it refers to the.
Seems to refer back to that. I just think you might.
No, I've already told the judge that it. I thought I'd already told the court that it refers back to the communication from the Commission.
Yes, you did.
I did say that, I believe. The second point where I was just saying where there is reasonable scientific doubt, then one should, we say, take the approach inherent in the precautionary principle, Commission's communique, worst case scenario, and then taking into account, this is the third point, and I go to apply this in ground 1 and 2. By definition, the worst case is precautionary, it assumes the worst. The alternative is to adopt an approach which proceeds on a more optimistic basis without being certain that that will take place. So if that approach is adopted, there'll be a risk that the worst will happen even though it hasn't been accounted for. This may be a very good example, I think, another example to my answer to the question posed by my Lord Justice Singh about how one approaches applying Wednesbury. So Wednesbury is applied in a different way when you're applying the precautionary approach than when, for example, you're applying a benevolent approach to planning officers' advisory report in the non-habitats world. There it may very well be that actually he's got it wrong, but that's just, it's still nonetheless a Wednesbury reasonable decision. Best judgment that he could make. So ground 1 then turns to the national average occupancy rate. So I did say before, in answer to my Lord Justice Mal's question, I do say that we both criticise, even on ground 1, aspects of the Natural England guidance, but fundamentally it's on, and partly it's because it's apt to lead astray, as it has done this officer and this committee in this case. And whilst obviously I've taken your lordships to the authorities looking at in the Dutch nitrates case, the extent, and we'll come on to that in a bit more in ground 2. In ground 1, we're not looking, I don't want to say rocket science, in terms of looking at the figures of housing occupancy. And also going back to what was before the officer, as we'll come on to see. What was put before the officer, and it came from Mr and Mrs Wyatt, they had gone and done the research at the ONS and found for larger houses, there was a larger average. And then we have to see how was that treated by the officer. So at first instance, we argued that the occupancy rate of 2.4 plainly couldn't represent and didn't represent best scientific evidence. Before them was evidence submitted, amongst others, by Mr and Mrs Wyatt, whose legitimacy wasn't called into question. It wasn't said, no, that's not right, but was better. I mean, to call it scientific evidence is, no disrespect to them, is elevating it quite, but was more accurate. The judge accepted the first part of the argument that 2.4 was not the best scientific evidence, but it was following exchange of emails with parties after the hearing, concluded the appropriate assessment was nevertheless lawful, so therefore sufficiently precautionary. There are two issues, we say. One, was the judge right to conclude that national average occupancy 2.4 was not the best scientific evidence, as he did at paragraph 80? And the answer we say is plainly he was right. Two, but if so, was it open to nevertheless conclude the appropriate assessment was lawful, as he did at paragraph 86? So obviously we say answer to question 1 is yes, answer to question 2 is no. We say, and I make two points first. The judge was right to conclude 2.4 was not the best scientific evidence. He had also the 3.0 figure that was slightly lower than the Wyatts by Dr. Neal, which also took into account not the question of size of house, but also for Fareham, where, the area. The arguments made to the contrary by Natural England, the council in their notices in this court, rehash the arguments made before the learned judge, which we say he rightly and comprehensively rejected for the reasons at 61 to 84 of his judgment. But the judge was wrong to conclude that the appropriate assessment, not being based on best scientific evidence, which was his finding, that although the best scientific evidence had not been used, the appropriate assessment was lawful. But you said this is novel and contrary to authority. We're unaware of any authority that says on appropriate assessment, where you actually have a finding that you've not used the best scientific evidence, that it's nonetheless sufficiently precautionary. And obviously, we'll come into it briefly, he relied on some of the factors Miss Potts mentioned in her witness statement. So matters not before Miss Potts' evidence, she didn't give evidence to the inquiry. There was no... So...
Sorry, to the inquiry.
Sorry, not to the inquiry.
She
to the committee.
She didn't submit representations to the LPA.
That's the point.
Yeah.
My lord's quite right. Sorry, apologies. If we look at the, we've seen that we don't need to go back to it, but your lordship's note under step 1, stage 1 of the advice note, there's acknowledgement that the development will will cause additional nitrogen discharges, and Natural England advises that sufficiently evidenced occupancy rates are used. And where I say the guidance, where in one sense you could say, and what's wrong is with the guidance, my Lord Justice Singh put to me, why I said it's apt to mislead, because it begins as a starting point that one uses 2.4 as a starting point. Paragraph 4.18, my lord, page 11. New housing, etc. This can cause nitrogen to determine the additional population. Necessary that sufficiently evidenced occupancy rates are used. Natural England, as a starting point, local authorities should consider using average national occupancies as consistently applied. This can be consistently applied to all affected areas. Then it goes on and says, however, competent authority may choose bespoke, tailored to the area, etc., etc. Now, conclusions that inform a bespoke need to be capable of removing all scientific doubt. But that applies also to a national average as well. And of course, whilst it may be a starting point, as I answered to my Lord Justice Singh, it can rarely, say by a bizarre coincidence, ever be an ending point, where you could possibly, on a Wednesday basis, conclude that the best scientific data available to you is a national housing occupancy rate. And this is again, this is not, I've taken your lordships in the Dutch nitrate stakes to various bits of evidence that the European Court of Justice looked at. We're nowhere near that level. We're on the most simplistic level of, if you've got a 4 to 5 bedroom house, what is in Fareham, what is the best evidence around to show how many occupants there are likely to be? Now, we're not even saying that will always be perfectly, absolutely sure. Don't need to say that, but it clearly is better than just taking a national average, both in terms of location, in terms of house. Take a step back.
But can we just, before we take the step back,
yes,
take another step back towards the first sentence of paragraph 419. We need to read the whole sentence, obviously, to get its sense. And I'll leave out unnecessary words for the purposes of my question. Competent authorities may choose to adopt bespoke calculations where they are satisfied that there is sufficient evidence to support this approach. So the permissive may, which you said it should have been must, I think, in your earlier submission. But the way they've put it is that authorities may do that where they are satisfied that there is
Yes.
sufficient evidence to support that
Yes.
approach. That's what the guidance actually
Yes.
is.
Yes.
That's not compulsive, it's permissive.
Correct.
Now, just take it in stages. Did the authority fail to discharge even that advice, is the first question.
Well, in my submission, yes, when we look at the reasons, which I was going to take you back to the officer's report, how the officer's report looks at it, because one of the issues about immediately jumping to local occupancies is if you don't have the official data, you can't just have a one-off snapshot, things like that. So if one looks at the case officer's report, and your lordships goes to tab 21 of supplementary bundle.
Yeah. Let's just find the relevant part of the report.
I think paragraphs 838,
Yeah, page 236.
236.
So they start by reciting the guidance in 418. Yes. And then they go on to recite the guidance in the first sentence of 419. That's in the second part of 838, isn't it?
Yes.
Then they go to refer to the concern that's been raised, which would include concerns raised by Mr and Mrs Wyatt, I think, over the use of the average occupancy rate of 2.4. Then they acknowledge that some have expressed the view that a higher occupancy rate ought to be applied. And then, whether adequately or not, do they not go on to grapple with those contentions in the following text? Is that the right way to understand this?
Yes, so if we go, third parties have noted the council have used bespoke calculations. So that's where they use lower calculations than the average for the care homes,
Yes.
ones in care.
It's a point that's been picked up by third parties.
Third parties, and it's also a point when come that is now picked up by the provisional guidance of Natural England says you shouldn't do that. You shouldn't jump in and jump out because you're going back to averages and you then cherry pick. But we'll also see what it says about. But let's look at 840. Your lordship's asking me to acknowledge that some houses will have more than an average number of occupants. So of course, the case that some will have less. So they say, well, it's well sourced. Yes, it's a well sourced average for the whole country across all different sizes of houses, and which has been shown to be consistent over 10 years. So that the average house of whatever size across averaged out the locations is 2.5 over 10 years. So that, of course, for the reasons I've taken your lordship to, that is not best scientific evidence because averages can't be relied on to. We're dealing with the effects on the Solent.
But look, for the moment, let's just look at what they did and then by all means make criticisms of it. But I think we just need to see what they actually did, don't we, to be clear about it. As stated above, the Natural England methodology allows bespoke occupancy rates. However, to date, the council has only done so to lower, not raise the occupancy rate. And then they say this, and where clear evidence has been provided to demonstrate that the proposed accommodation has an absolute maximum rate of occupancy, then they go on to sheltered housing, which plainly isn't the present case. And then this at 841, in all instances, it is the case that the Natural England methodology is already sufficiently precautionary because it assumes that every occupant of every new dwelling is a new resident of the borough of Fareham, and then the precautionary buffer. And then the conclusion, 842, officers do not consider there to be any specific justification for applying anything other than the recommended average occupancy rate of 2.4. Now, is that an echo, 842, of the second part of the first sentence of paragraph 419 of the advice note, where they are satisfied that there is sufficient evidence to support the bespoke approach? Is that how we should read it, or is there some other way we can sensibly read it?
insofar as it is, well, look, it is clear that the officer's advice is that they should not depart from the national figure to a lower one. And then, if now is the appropriate time, we'll deal with those reasons as to why they're flawed. The first point is that at 839, none of those reasons go to why taking the national average of 2.4 is best scientific evidence for what, and this is where this is, if you'll forgive me to allow me to step back, that I was about to step back before we step back, is to ask what is the purpose of why we're going through this exercise? What is the purpose of this guidance for the Solent? And the purpose is to get the best scientific evidence to establish the likely increase in population from a proposed development. That is the underlying key from which you then look to see about whether you can be sure, which is what the guidance says you need to ensure with certainty there is no increase. So the question therefore is, does the application with the starting point justify that you stay with the starting point, or that is sufficiently precautionary in this particular case? And the answer in our submission is no. Nothing in 839 up until third parties answers that question. The fact that it seems to be being suggested by the officer that they will, you've got this is an average, so you've got larger and smaller. There's a suggestion that things will balance themselves out. That may be the implication, because one can't see what the relevance is. So the first part down to third parties is no rational justification for staying with 2.4. Third parties have spoken to the bespoke calculations. Now that was when they were going down to a smaller occupancy level, and then it's 840. So you know some houses will have more than the average number of occupants. It's also, of course, that some will have less. Now, just pausing there, that's making the point I've just made to your lordship before. That seems to be being advanced as a justification for staying for the national average, 2.4. The reasons I've already submitted, that is flawed. The national average is not what we know on any reasonable basis, and certainly what we can't discount with certainty will be what will be happening at Fareham on the Solent in Chichester.
It might be said, I suppose, that the conclusion in 842 expressly begins by saying, taking the above matters into account, that must include 841 and perhaps 840, but 841 says two things which are simply wrong. One is that the Natural England mythology assumes that every occupant is a new resident. Well, it doesn't. At least nobody's been able to show us so far where it does. And the other is that there is a precautionary buffer of 20%. Well, the methodology makes clear that the 20% is to be applied at the end of the calculation and is not a justification for taking less than the best available evidence of the occupancy figure. Now, suppose that's the case, that the officer's report simply says two things which are wrong about the Natural England methodology, but then comes to its conclusion. What's the consequence of that? Is that something they're entitled to do, or if they're not, then why not?
My lord, no. And on buffer, we make that point in the guidance, as your lordship rightly says. Each of the factors stand alone, and that's what the guidance say. And that is right, and that is...
And that was the judge's view also, on
yes,
20%.
Yes, and that is an error. Now, the one thing I should say in respect to the first point Now, your lordship is quite right, and we're puzzled about this. There is nothing in the guidance that says the assumption on inward migration is that it equals itself out. But Miss Potts, in one of her later witness statements, does make that claim. But it was never put, it's not in the guidance, and it was never put by Natural England, as far as we're aware. We've been shown the email correspondence to the officer. I'd also say about that that assumption, again, doesn't help them, because even if the guidance said it, which it doesn't, your lordship is exactly right, there's no figures or there's no way of knowing whether that cancels something out. Again, it's like the buffer. It's exactly like the buffer. It's asserted in Miss Potts' witness statement, which filed, I think it's second or third witness statement, but it doesn't appear in the guidance. It was never before the committee. But in any event, it would be wrong in any event to rely on it for these purposes. Just in the same way it's wrong to rely on the buffer. So I'm agreeing with your lordship.
But is the planning authority not entitled to say, well, we've looked at the Natural England guidance, we've considered what it says, but we think departing from it because of these factors, there is sufficient leeway, and that's our assessment as the people who have to make this decision.
As I understand it, I already read the report, and it's never been part of the defendant's case, as far as I understand, or my understanding, that the officer was advising members that they were departing from Natural England's guidance.
Well, they wouldn't have to be, would they, if 841 is to be read in a slightly wider context, which is that there are, if you look at the total methodology to which reference is made there are these other factors. Whether they've got them right or not is another question. But there are these other factors which give you, if you like, I won't use the expression buffer, but give you some degree of cushion or latitude in the overall assessment. So that if you are being conservative with your assumption about occupancy rate, you are nevertheless safe to do so, because overall, the whole analysis is a precautionary analysis, and a sufficiently precautionary analysis. That would be another way of reading 841, which would fit with the, if you like, the pattern of analysis in those 6 paragraphs. 5 paragraphs. Perhaps. That's not to say it's right or wrong ultimately, merely that that's one reading of it.
Just it's the first time that reading of it's been put. I'm just
All
processing
right.
it. I'm not saying it's wrong.
Want to test the case, you see.
Mine. So could you, Lord? I was just looking. One moment. Your lordship just put
to
what
help you
now say.
To help you, Mr. Jones, the analysis would be, in basic terms, this: that the officer sets off in the knowledge of what is said in paragraphs 418 and 419 of the advice note, recognises that 2.4 is the starting point, however, considers whether this is a case in which they can be, quoting 419, satisfied that there is sufficient evidence to support the bespoke approach, discusses that possibility in 839 and 840, discounts it for the reasons given, and then asks the question, well, can we be safe in doing that? Answer, yes, we can, rightly or wrongly. Yes, we can, because of these other factors to which reference is made in 841, which go to the whole analysis, and then the conclusion in 842.
Well,
That's not to say it's right, simply that that's one analysis of what was done.
If that's what was done, it was also flawed, partly for the reasons I've just given in going through the paragraphs, but also, and I was just looking at the Natural England's guidance. Natural England's guidance, as was because of the uncertainty, each element was inherently uncertain. And I just wanted to, just looking to get there's a passage. So at 4.7, my lord, page 8.
Yeah. Yes.
So if you just look at the approach, so 4.7, when you look at the neutrality calculation, key inputs, assumptions, as we've looked at this before, was based on the best available assumption. It has been developed as a pragmatic. However, for each input, there is a degree of uncertainty. It was put to me about whether I was saying that was unlawful. I said that was a bit. I said no, it wasn't. So then see what's done with it. For example, there is uncertainty associated with predicting occupancy levels, water use for each house, in perpetuity. That's partly because they make assumptions under building regulations that can't be enforced. Also, identifying current land, farm types, and the associated nutrient inputs based on best scientific evidence, research, and professional judgment. And again, we don't obviously accept that on ground two, but again, is subject to a degree of uncertainty. Our advice to local planning authorities: take a precautionary approach in line with existing case law. So they're also got to look at existing legislation and case law when addressing uncertainty and calculating nitrate budgets. So the guidance, in my respectful view, that's why it's partly a dangerous guidance and leads. It's carefully drafted in some ways, but it leads local authorities astray because they're saying, well, you've got to look at case law when addressing uncertainty and calculating. This should be achieved by ensuring nitrate calculations apply precautionary rates to variables and adding a precautionary buffer to TN calculated for developments. Precautionary approach to calculations helps solve it. So what you're doing is at each stage you have to apply a precautionary approach. What you can't do, in our respectful submission under the guidance, is to say it doesn't matter whether this isn't right or best evidence because we've got built-in precaution elsewhere. The reason each of those other elements have to be approached on precautionary is because they're inherently uncertain.
So you say you can't steal some of your buffer to use
Correct.
at earlier stages of the calculation.
Exactly, my lord. In order to make this, and it's not our guidance, I'm not clear, but in order for this to get each element is uncertain and then is justified on the basis that its uncertainty, which none of which is specified, or the parameters, is subject to sometimes an unspecified, sometimes, in the case at the end, a 20% buffer. But it's quite clear each of those are separate. So what you can't do is rob Peter to pay Paul, to use your expression. And that's precisely what the officer did, if on the analysis that my Lord President puts to us. And that's where it's interesting then to see what then happened when we had the exchange. Can take your lordships to the post-hearing exchange, which your lordships will have at core bundle, tab 14. Yes, page 151. It also reflects here how the case, certainly how Mr Justice J, we say, had properly understood the case as presented by all the parties. So he begins, imagine
is this really anything more than the same kind of interplay that we're having in the course of oral argument, by which most judges wouldn't particularly want to be held, and what matters is what he says in his judgment.
Well, my lord, that's why it explains what may seem curious in the judgment. Let us say to reconcile what is said in the judgment, but it's also it reflects what the case was. He says, we know that the LPA would have refused permission in this case if the figure had been in debt. So the issue was, if I took the view that wasn't the best scientific figure, it would have been in debt and it would have refused. Does that mean the claimant must win on ground one? And then that's the introduction by the judge of section 31(3)(c) with the decision have been the same. And is this
the
because...
remedy point? Section 31(3)(c) goes to remedies, as I understand it.
Yes.
When I read the judge's judgment, I didn't find that he found a ground is made out, but I'm going to decline a remedy in my discretion under section 31.
That's right.
So as my lord has just asked you a moment ago, why are we looking at this post-hearing email? Isn't it the reasons he gave in his judgment that we need to scrutinise? Yes,
well, we can look at the reasons, but I will take your lordship to the reasons, because I say the reasons we submit don't sustain the judgment that was reached. I mean, I've already dealt with the point. You find that it's on best scientific evidence. That's the point. I'm not trying to embarrass, rather than explain where we got to. What I would otherwise be submitting was slightly incomprehensible. Well, say it is position that the use of best scientific.
Let's use your last 45 minutes effectively, as effectively as you would wish to use them, Mr. Jones. By all means, take us to the judgment if you'd like us to look at the judge's reasons. But bear in mind, you've got 45 minutes.
We've set out the reasons we've set out in our skeleton argument, which the lordships have read, and can I just then refer your lordships for your lordships' notes, and just if your lordship wishes to turn it up, I will go to it. But bearing in mind my 40 minutes, Dr. O'Neill at tab 14 141 146, and here we are dealing again. I would emphasise this is not rocket science, best scientific knowledge. This is well in the scope of traditional Wednesbury, notwithstanding my previous submissions, is the average occupancy rate for a 4 to 5 house in the Fareham area, and he gives that evidence. It's never been suggested that that isn't right. I mean, there isn't any dispute that this isn't right. He says and he says at paragraph 24, 2.4 occupancy rate may accurately capture over time the average national occupancy rate, but even the most cursory assessment of the base available data objectively indicates that 2.4 occupancy rate does not accord with the average occupancy rate of a 4 to 5 bedroom house in Fareham, which is what matters for the purpose of the nutrient budget. So we say the judge was right at paragraph 80. So there's no dispute what Dr. O'Neill is saying on this point. Also, the figure, as the judge said, was both available. This wasn't some crypto software analysis. They're available and more statistically apposite. It cannot be sensibly argued, and this I'm quoting from the judge, that a figure based on a narrow and more representative cohort is not more cogent than a countrywide statistic. And I adopt what the judge says. So, on also relying on Dr. O'Neill's comments at para 33, the judge was rightly critical of the fact that much of the justification of 2.4 is based on future demographic trends. That's at paragraph 74. he rightly found that relying on future trends and that they will balance out was inconsistent with the Habitats regulations. That's 74, 78, taking your lordships to the case law on that as well.
Where is 2.4 justified on the basis of future trends? That's not in the officer's report.
No, this is in the evidence that's been put.
That's just response to Ms Potts, is it?
It's Miss Potts, yes. Yes, I mean, you'll see most of what, this is the thing, it's a published document, but for this case, you find out more about Natural England's guidance in Miss Potts' various witness statements. And Dr. O'Neill was responding to that point. But it's not, your lordship's right, it's not in the guidance. It's not in the officer's report. But, and so that's why I came back to before, and I know it's maybe, and I shouldn't have been, and I apologise to the court and to my Lord President, but why I was, we focused on what we understand to be right, the decision by Fareham, and also then by, obviously, we have to appeal from the decision of Mr Justice Jay.
Your grounds of challenge, and in particular ground 1, was about the decision of Fareham.
Yes.
It was not in terms about the lawfulness of Natural England's advice at all, was it?
No, it was how it was applied, but it's more, as Natural England has come in, and as the case developed, but
grounds of judicial review are grounds of judicial review.
Yes.
And then appeals to this court.
Yes.
Lie from what the judge below has done.
Yes.
It does seem to me one has to be very careful. And this may be a point in your favour.
I was trying to, it was my fault, and I do apologise, but that's why I was saying we haven't launched judicial review proceedings against Natural England's guidance. I mean, my clients, as worthy as they are obviously were concerned about an immediate planning application.
No, that's very helpful clarification, speaking for myself, because there have been times at which the impression may have been given that this case was about the lawfulness of Natural England's advice. Whereas I think what you're confirming, and that's certainly how I've read
on
the
ground
grounds,
1, yes.
Yeah.
Ground 2.
Are there any? Well, right.
Ground 2, we do criticise.
Ground 2, the appeal.
Yes, the use of averages.
But forgive me, this is not just a pleading point.
No.
It matters. In the original 8 grounds of judicial review, was there ever at all any challenge to Natural England's advice? And if there was, please say so. I'm not trying to slip you up. I just want to know what the answer is. Because that's what the appeal is from, is a dismissal of a claim for judicial review. So we need to know exactly what was the ground, what was being challenged, on what grounds.
Tab 26.
Yeah. I've looked at the summary of your grounds of challenge.
Yes.
Ground 1 is the one that we've just been considering.
Yes.
Page 354.
Correct.
This is a very helpful summary of your 8 grounds. Ground 1, as I read it, that's a challenge to Fareham.
Yes. Right. They're all against the.
They're all against Fareham.
Yes, they're all against.
So can we be just absolutely clear? It is no part of your challenge in these judicial review proceedings that Natural England's advice is unlawful.
We don't challenge. We have not challenged the advice.
That's a very helpful clarification, if I may say so.
We just haven't challenged it.
Right, that's fine. Thank you very much.
I think at the time we'd have been out of time. Well, you know how that. Anyway, that's another issue.
Right,
so what we
ascertained that the challenge is to Fareham's decision making.
Yes, and it's
and you're now submitting. Which ground are you on now? Still, are you on ground 1 still, or are you taking us into ground 2?
I think, given my 45 minutes, I'd better go to ground 2. Otherwise, I'm not going to.
All right. So everything up to this point is both grounds 1 and 2, but more ground 1, I suspect.
Yeah. Just before we go there, could we just look, because I won't have time, I think things we challenged the decision of Fareham, and just in terms of Natural England have put in, and their provisional new advice, which I've got in a separate bundle, and can I just want to make some points about it. I don't know what's going to be said about it.
Well, to be fair to you, Mr. Jones, I suspect that additional material may be somewhat off-piste for the moment, and you will get the opportunity of replying to anything that's said about it. Well, what we're very keen to hear about is your appeal.
Yes, but I would like to say a couple of words about it.
No, I'm seeking to save you time.
No, I know, but can I go then very quickly, and I'll just make these points, and then they come back, and I'm grateful to your lordship. Can we just? We do say that, as it's, albeit provisionally, very much supports what we had been saying in ground one. The advice now says that national averages should only be used if it, and see page 10, corresponds to the local average in the area, which it didn't here. That was my answer to my Lord Justice Singh. It goes on to say if the national average occupancy rate does not correspond to local conditions, then a locally relevant average resident per dwelling value may be more appropriate. Our query would be on that, why would it ever not be, but there we are. Then says a key source of evidence will be the average occupancy rate from the census for the relevant local administrative area, which of course is what was used by Dr. Neal in his witness statement. Insofar as the cross appeal is that the judge was wrong to find that that the average was not the best scientific evidence, we cannot see any basis why there should be any change in the position. All of these matters, as the judge indicated, were matters which could have been taken at the time.
Perhaps I could just say on the updated advice, and I think this is a point in your favour, but I'll put it there so that others can comment, is that what struck me, excuse me, what struck me is what is not there, which is what is not there is anything about Ms. Potts' evidence on non-linear relationships and assumptions about incomers.
My Lord, yes. I mean, it cannot be right, I just make this point, that ordinary people have to bring proceedings in order then to be met you challenge the local authority, you then have Natural England coming, their reliance on guidance, and then explanatory material that isn't in the public domain. But it's a side point. But my Lord, yes, is the answer. I go to ground 2, and again, it's the reliance of the officer places, because at whatever Natural England's guidance or whatever is, the competent authority is Fareham. It is not Natural England for the purposes of compliance with the directive. And as we've said, at all times the guidance said that the competent authority, Natural England, said they have to satisfy themselves, i.e. Fareham, of the case law and existing legislation, that they are sufficiently precautionary. And so that is why we say that the approach that they adopted on nitrogen losses was not sufficiently precautionary. Shortly one can go, conscious of time, to Dr. O'Neill's witness statement, supplementary bundle, tab 14, 138.
Which part is it?
It's supplementary bundle, tab 14 and page 146.
Thank you.
Paragraph 36, and there was no issue about it, but just in case anyone wonders, he says the selection of correct land for the site as a matter of judgment, which I'm not qualified to make an assessment here. He's talking about whether things should be grazing or crop, that sort of thing. But the 4 points that he made, he actually made probably 6, can be shortly stated. First, a statement of the obvious. If you incorrectly identify existing land, significant risk you'll get the wrong nitrogen level, and that affects the baseline. Secondly, where doubt exists as the accuracy of data to inform appropriate assessments, as in the current instance where evidence provided by local evidence provided reasonable doubt, it should be the task of experts to gather the data relevant for the specific plan or project. So that's specific measurements of the appropriate environmental variable data. That touches on what we've seen in the Dutch nitrates case. There is simply, this is all about protecting the Solent. You've got to see what an individual site and where its location and how it will impact. They're related because the farm scope and model is intended to provide average leachate data, variety of farm types, agricultural uses, to allow the assessment of cost and effectiveness of mitigation methods against multiple pollutants and multiple targets. It's not intended to be specific site requiring data for habitats regulation assessment. It relies on a number of assumptions, may not necessarily reflect the actual process of a given location. This is a national. In the current instance, the evidence, it's been to avoid what we were told in the witness statement, time-consuming, costly process of calculating the actual leachate figures from proposed site. So that's what we're told. But as noted above, that doubt exists. So then, fourthly, and this is from second witness statement of Natural England, para 59, farm scope and model used in agriculture, loose of the methodology, assesses nitrogen and nitrate nitrogen rather than total nitrogen. While nitrate is normally the largest component of total nitrogen, quantities of organic nitrogen are significant. Thus, the land use change element of the methodology may underestimate TN leaching, albeit this error will affect both the total discharge and the efficiency of neutral measures equally. It's therefore likely to have negligible income, but is to be taken into consideration in the buffer. So there we also have an uncertainty, and there's just an example. It goes on the buffer point, where the buffer is then being relied upon. It goes back to my answer to my Lord Justice Males, where I say you can't rub Peter to pay Paul, but that's what's being done. And then where total nitrogen levels may significantly underestimate the use of non-precautionary occupancy figures in accurate assessment of land use, this further uncertainty only multiplies those uncertainties to a level that may significantly exceed an arbitrary 20% buffer. Then he also makes this point, the case where there's a possibility of authorising activities which might subsequently affect the ecological situation of the sites. This is, moreover, the methodology of the advice note is to leave open the possibility a site may be granted permission being nitrate neutral, even though it does add nitrates to the Solent. And then he comments on the point I took your lordships to, which was applied by Fareham, that if you look at land over the 10 years and see whether the site would have been in the event used for what it would be used for if planning permission was refused. I call this, we're familiar with this as a fallback position. This is completely contrary to a precautionary approach. The baseline nitrogen rate is that calculated after having considered what the use of the site would be if permission was refused. It's then offset against the nitrogen rate associated with the proposed development, where he says it's flawed because it leaves open the possibility a site would be afforded a certain baseline, even though at the time of the baseline condition survey had no nitrogen output. So when you did the baseline survey, which this is measured, a particular site would have no or little or no discharge of nitrogen. But when you come to put houses on it, it's assumed to have a discharge of, in the last 10 years, it could have been used for cropping or grazing. So that's even beyond the 5K or the 5 tonnes that's given for land that hasn't been used for agriculture. And then he makes the point, although he's not a lawyer, it assumes also that discharge of nitrates into protected waters can be done without any other consent, simply because it doesn't require planning permission. So we do say that Fareham were wrong to take the approach in this respect of making assumptions in respect of low land grazing, which fed in to the nitrate budget, which then produces, setting aside the occupancy rate, a negative figure rather than a positive figure. So that, in essence, is ground 3, that the approach to is not precautionary. And the guidance of Natural England tells local authorities they have to expressly have regard to the case law, and I've taken you to your lordships to the case law.
So just to be clear, which ground precisely we are dealing with at this point? There was a transition, was there, from ground 2 to ground 3 at some point?
I'm sorry, did I say ground 2? I meant ground 3.
Didn't you?
Sorry, when I said ground 2, where I've just taken to your lordship.
When you said ground 3 just now, you meant ground 2.
I did.
Yes, you said it was a slip of the tongue. Fine.
I'm sorry.
So I
yes.
thought I'd written down ground 2.
Yes,
I think you've been submitted after that. Was ground.
I was getting carried away with
fine.
myself.
All right, no, that's fine. It's very clear. Thank you. Ground
sorry,
2.
it was only ground 2. Ground 3.
Now we are going to ground 3.
Ground 3, which is buffer.
Thank you.
And again, I mean, most of the groundwork has been done. One second. So, first thing is, what is the purpose of the buffer? The judge said it was to provide an extra level of protection. That's 111 of the judgment. But it's not. It's not there to provide an over level of production which is required over the habitats regulation. It's a critical part of the methodology, which is necessary to give the degree of certainty which the guidance says.
Can we just look at what the judge said at 111?
Yes.
To remind myself of that. Yeah. Sorry. 111, yes. And you say he was wrong to characterise it as, what's the expression used?
So an extra
level of protection, yeah.
Yeah. Integral part, so far as...
You say he was wrong about that?
Yes.
Yeah.
So, I'm putting the point as simple as the buffer can only be rational or demonstrated be precautionary if Natural England, or it can be demonstrated, relying on it, that it is able to show, one, what are the remaining uncertainties in the advice note it's relied on, and two, the buffer is enough to counteract them. So the advice note doesn't demonstrate that at all, and indeed the indication in the advice note is, as I've submitted, you don't rob Peter to pay Paul. Even in the evidence that's come through, there is no arithmetical calculations that demonstrate that 20% will be enough to counteract the uncertainties in the advice note, which aren't articulated in parameters. We did, in our reply, which you'll find para 35 Roman 3, supplementary bundle 18 228 said that if calculations had been disclosed, we'd expect them to be, since Natural England were putting in evidence, which had been carried out, that they would be disclosed, part of the duty of candour. So we assume rightly, and it's consistent with the evidence that's been given, that there are no calculations. And it's right that it isn't based on an arithmetical or algorithm or any other. So
I'm very sorry, Mr. Jones. You now appear to be criticising Natural England again.
Yes, but
and I may be right.
Yeah.
I thought this was not a challenge to
No,
Natural England.
we're not challenging their guidance. We haven't launched judicial, but we are challenging Fareham's decision,
Right.
which relies, and in the guidance says, I've taken your lordships to, that although they're giving guidance, they say it is for the local authority, as competent authority, to satisfy itself. So as we pointed out, even on the occupancy rate, Natural England expressed no view. It is for, and the guidance tells the competent authority it must satisfy itself on all of these parameters itself in line with the case law. And we are saying that if it adopts this approach, it is inconsistent with the case law. Now, Natural England, in fairness, have made it very clear that their advice is over to the competent authority. They have to satisfy themselves. They don't just take the advice and eat it all up, unquestionably. They've got to satisfy themselves, and it's clearly stated in the advice in more than one place that the competent authority has to satisfy itself based on the case law. So therefore, though it may have collateral effects for Natural England, we are challenging their reliance on matters which we say is inconsistent with the law and case law.
What buffer figure do you say Fareham should have used?
There's no evidence to support a buffer figure.
So 0.
What they should have done, our case before them was that they should have used the best evidence. So on housing occupancy rates was the best evidence. They shouldn't use.
Yeah, we got that. Assume they've used the best figure on housing evidence.
And
For ground 3, we come to the end of the calculation, and the question is, do you apply a buffer or not? And if you do, what is it? What's your case?
The answer would be no, because our position has been that you use the best evidence. So
best evidence, but no buffer.
There might be a buffer if you've got the best evidence, but there isn't the best evidence on a buffer. The buffer is parasitical on an assessment of risk.
I'm afraid I'm completely in the dark as to what you say Fareham should have done in performing their nutrient budget calculation when having used all the best evidence they could, they got to the end of the calculation to what in the Natural England advice is the buffer stage.
Well, if they had used, which is on that hypothesis, we don't accept, the best evidence, best scientific evidence available, then there may or may not be a need for a buffer.
So does ground 3 have any independent life?
Well, if it's been found that no, because it depends on how your lordships go on ground 1, whether you can then put in a buffer. I'm trying to do the calculations, but it's not.
Well, it would be obvious, I suppose. We wouldn't even have to worry about scales of Wednesbury, that you can't use the buffer illegitimately twice. Now that would be an obvious proposition,
yes.
I imagine, because that would be simply double counting. If, however, the buffer was sufficiently wide, there might be a reasonable argument for deploying it, as it were, across the whole calculation, rather than specifically on one aspect of it.
My lord, this is another scheme which this is not. But if, as I said in earlier submissions, you have your uncertainties, and you say your uncertainty is plus or minus whatever, and you go through, then you may be at the beginnings then to have a rational basis for how you calculate a buffer. But if my simple point is this on rationality, if you don't know and you can't quantify what is the uncertainty, even in parameters, then just as the journey judge said below, how can you know on a precautionary basis, or in fact any rational basis, whether your buffer is good enough? So if I don't know how much petrol my car leaks when I'm going to Manchester, and I have a tank which is my buffer, and I take 5 gallons, and I need 30 gallons or whatever to get to Manchester, I don't know whether when I start my buffer is going to be good enough, or I'll get to Manchester and I'll have a full tank, or I'll have no tank, or I won't get to Manchester.
Well, that makes it, as my lord puts it, parasitic on ground one. That proposition.
Well, it's parasitic on ground one.
It may be a point worth making in association with ground one, but it's really an associated point, isn't it?
If your lordships, I suppose, against us on grounds 1 and 2, then I think you found.
How can we sustain ground 3? So, well, that's the corollary, really,
yeah.
of what I've just said, isn't it? If we're against you on ground 1, if we were, what life would there be in ground 3?
Well, it goes to whether you're with us on ground 2 and that goes that.
All right, well then,
because that goes to the answer.
And if we were against you on 1 and 2, suppose
yeah,
if we were, then would 3 rescue the claim?
Well, you do the calculation and see on all of those bases whether they need to rely on a buffer or not. Because you'd have said on best scientific evidence, not relying on any buffer, that's sufficiently precautionary. It depends on whether. It depends on whether to do me down on ground 1, you need to rely on an assumption that the buffer is part of what makes it sufficiently precautionary.
Well, I think we know, don't we, that if we were against you on ground 1 and ground 2, and we apply the 20% buffer,
yes.
then the figures come out just in favour of granting permission.
Yeah.
From which it might be thought, well, if you can get your buffer up anywhere above 20%, you're probably on the right side of your case. But you don't put forward any basis for saying it should be 30% or 50% or whatever.
Or 15 or 10. No, that's our case. I mean, to an extent, I'm representing local people who we've managed to get some scientific evidence, but it isn't our job as to carry out the role of the competent authority. And nor is it this court's, but it is this court's, we submit, duty to ensure that the competent authority does do its job. I'm not asking, we're not saying it's a plan, but it's whether this court is satisfied that what has been carried out meets the threshold. So it's not. I mean,
well,
I'm not being difficult, but there's
not
no
our business to calculate an alternative buffer. I mean, that would be far beyond any formulation of what our level of scrutiny might be.
Well, my case to you is it's impossible on the basis of what we have to do that. And it's not something Natural England have done. They've just arrived at a figure.
All right, well, we've understood your argument.
Okay, so can I then turn to ground 4, please, which nothing to do with buffers, Natural England, or nutrients.
Section 38(6).
Yeah. So, well, I don't know what didn't the two of they were in the bundles below, but we've got the policies that they're not. There's one CS14, which is development outside of that was the, and then there's DSP40, which is set out. But we've got. I don't think CS14.
Well, they weren't set out in the judgment, were they? I'm not sure.
Just have a look.
Yes,
Yes,
before
they
he
were.
says
Well,
131.
Yes, and you also have the officer set out DSP 14 in his report as well.
He set out DSP 14 in his report, but he didn't set out CS 14.
No.
Well,
you happy with that?
I can't think there'd be any objection to your handing up the policies if you want to do that.
You had it. Thank you. So, although this comes on the end, it'll be 15 minutes. And it's
Well, to help you, I mean, so that to help you focus your submissions, the main contention might be here, mightn't it, that there was no delineated conclusion on the first part of section 38.6. It is a misreading, you say, of 883 to understand that the last sentence in that paragraph articulates a conclusion on compliance with the development plan as a whole. That's, you say, for the submissions you make, a misreading of it. So, if that understanding of what you're submitting helps you, that will give you a focus for your remaining 12 minutes.
Thank you, my lord. No, that's very extremely helpful. I'm grateful. So, your lordship knows plan-led system, but and the two states.
To be frank, you don't need to help us on that. We understand the plan-led system. We understand all the authorities on section 38.6, including, of course, City of Edinburgh, including Tesco and Dundee, including BDW, and including Hampton Bishop.
Okay. So CS14 just won't have seen, but in the 74, and you're very common development outside settlements. So it's just the first sentence that makes clear. Obviously, the plan position would be that it would adversely affect landscape character, appearance, and function. And then you go to, then there's the DSP 41 is basically the is an exceptions that and it's down where a local authority doesn't have a 5-year housing supply, and obviously it may be permitted, but obviously we emphasise all of the following criteria have to be met, and so what is common ground, not all of criteria 2 was met, and we say it's a matter of interpretation, which is a matter for the court. That means you're contrary to that policy. It's not, and therefore it isn't a case of DSP 40 being more important than CS 14 and other policies. That is how it operates. That's how the plan operates. And so the first question is, as my lord said, stage 1, is there a clear finding that there is a breach of the development plan? Answer, we say no. And
I'm sorry, the way I put it was, and I was deliberately putting it this way, the development plan as a whole, which is what authority says, which admits the point that some policies can be in favour, others against, others neutral. But an overall assessment needs to be made of whether there's compliance with the development plan as a whole. I think that's what authority says.
Yes. Well, the reason why I want to say use these two policies is that isn't really one of those cases, my lord. Because sometimes, as your lordship is absolutely right, you'll get some policy that encourages retail development and another one heritage. So they're pulling in different directions. But this isn't a pulling in different directions case. This is a cogent planning and development plan. How you allocate housing development. So basically CS14, which this is, development outside settlements, is no. So the policy is no. And then policy DSP 40, if you haven't got 5-year housing supply, you may be then brought back into the fold of being consistent with the development plan, but only if you meet all of those criteria. And it didn't meet all of those criteria. So the short point is there is no pulling in separate directions. There isn't one policy more important than the other. In fairness to Fareham, their development plan was cogent and rational. It says, if you're outside in the countryside, no. But if we don't have a 5-year housing supply, and will be aware of the consequences of that. Subject to satisfying these 5 conditions, you will then be in accordance with the plan. But if you don't satisfy them, you're still out in the cold. Next stage then is to go on and consider whether other material considerations, tilted balances, whatnot, will change things. Question is, was this properly interpreted, properly applied? And very simply, the answer is plainly no. And without going through it, there was an emergency. My learned friend has pleaded, and when one looks at the way it's pleaded, how it's argued, a changing position, because it is, the officer's report is, let us say, Delphic in the extreme to understand. And simply, one cannot read that and find even with the most benevolent construction, a lawful approach to in accordance with section 38(6). And of course it's important because you start off with a presumption that is rebuttable, but a presumption rather than just a weighing in the balance or making a judgment that one policy is more important than another. My submission, properly understood, you look at those policies, no, this isn't a case of pulling in different directions. It was a consistent approach. The learned friend put it in his detailed grounds, just yeah.
Page 280.
Thank you very much. Page 280. Uh, 280. Reminded the we see 71. Reminded of 38. So then it says the planning officer's assessment of the planning balance in section G 8788 to 87, clear guidance to enable them to determine. Paragraphs 880 to 883, the planning officer drew together his assessment of the proposed development in accordance with those policies of development plan that he judged to be of the greatest materiality. His conclusion on the first stage, stated in 883, on balance considered in accordance with the development plan as a whole. Proposed development merit approval. Now, pausing there, if that was right, that's an error of law because it wasn't in accordance with the development plan. He acknowledged that the proposal did not fully satisfy DSP 40. If you look at the report, though, there is nothing in the report that says conclusion that overall it was in accordance with the plan. In my own friends, skeleton argument, he submitted that it was such that it merited approval. And when one then goes to the officer's report, one finds and one sees it set out at 151 by the judge. 880 notes, contrary to policies, this is at page 132, paragraph 151 of the judgment is set out. There is no finding at 88 and 881 of compliance with the development plan as a whole.
No, that is said to come at the end of 883.
883 begins, there's a clear conflict with development plan policy CS14 as this development is in the countryside.
It's the last sentence of 883.
Yes. The scheme is considered to satisfy 4 of the 5 criteria and give more weight to this policy than CS14. balance when considered against the development plan should be approved. So pausing there, there's no, first of all, no finding of whether that means it's in accordance with the development plan policy.
How else do you read it?
Well, if it is, then it's wrong, because it's not in accordance with the development plan, and it's not a case that more weight should be given to this policy. That the policy.
Well, that's a matter of planning judgment.
No,
classically, surely.
no, it's not. Well, with respect, it doesn't comply with the policy. So therefore, a notion that you give more weight to a policy that it doesn't comply with is plainly erroneous in law.
Well, you may submit. I don't know if you do. I'm not sure that you do, but it's open to you to submit, I suppose, that was not a rational planning judgment, but a planning judgment it assuredly was.
Sorry.
Just read the words.
Yep, I've read the words, my lord.
Yeah,
There isn't compliance, my lord. My submission is very simple, and you may reject it.
Well, what is your submission?
My submission is there is no compliance with policy CS14, which is a matter of law.
Right. So you're saying that's an earlier conclusion, isn't it?
Therefore, it is plainly unlawful.
Because he says at the beginning of 883 there is a clear conflict with development plan policy CS14 as this is development in the countryside. Is that wrong?
He is saying that DSP 40 should be given more weight than CS 14.
Yes.
My submission to you, Lordship, is there is a clear breach of DSP 40. It doesn't comply. That's a matter of law. On the finding of fact and on the interpretation of the policy, it doesn't comply with DSP 40. It's not you comply with some of the criteria, you have to comply with all of them. That's the policy. So that's my first submission. Therefore, when you then go on to determine, as your Lordship has put to me, he's clearly found it's in accordance with the development plan as a whole. That is legally flawed. Because
all right, you say it's legally flawed, but do you accept that is the sense of the last sentence of paragraph?
I frankly don't know the sense of the. In my submission, it's incomprehensible.
All right, so you submit that the last sentence of 883 is
yeah, we've had various versions put in defence of it, but all versions are unlawful. My submission that we've had. So I'm dealing with the version my Lord is now putting to me. So the first point is, if it is being said that that it's in accordance with the development plan. First point is, this is not a case of, as I've said, development plans independently, policies pulling in opposite directions. These two policies, DSP 40 is intended to be an exception policy to policies such as CS 14. DSP 40 makes very clear you have to comply with all the criteria. It's common ground that it doesn't. Therefore, it doesn't comply with DSP 40. If you are then saying you want to weigh up the criteria that are in DSP 40 with which it does comply with, okay, you then do that. It'd be bizarre to do it because contrary to your policy, under other material considerations, having accepted that it was in breach of the development plan. If, as my Lord is putting to me, this report is saying it's a finding in conformity with the development plan, it is plainly wrong as a matter of law. Insofar as he's saying he can then give weight to a policy to which the development doesn't comply and it outweighs CS 14, is plainly unlawful and irrational. In fact, it's contrary both to DSP 40 and CS 14. So you can't salami slice policy and take the bits that you like and say there's compliance with the development plan. If the policy had said, I go back to it, meet some or any of the following criteria, then I accept your Lordship's point. What's been put to you, I know, is a hypothesis. But it doesn't.
I simply asked you whether the last sentence of 883, right or wrong, articulated a conclusion that, when considered against the development plan as a whole, the development was found to be in accordance with it. That's all I asked you.
Well, my submission, if it is, it's unlawful.
Well, that's the submission you make, but that's a separate point. That you say that if it is such a finding, it's irrational and unlawful.
Well, the reason your lordship no doubt puts it like that, because it is suggested, and I agree, the scheme is considered to satisfy 4 of the criteria, and in the circumstances, officers consider more weight should be given to this policy than CS 14 as such. When considered against the development plan as a whole, the scheme should be approved.
Well, I think we understand your submission.
My lord, yes. So, I have nothing further to add, my lord, unless...
Thank you very much, Mr. Jones. Yes, Mr. Mould.
My lord, first of all, I produced a fairly full skeleton argument.
Yeah.
And given that we're seeking to move fairly swiftly, if you'll forgive me, I'm not going to go into that in great detail. But seek to encapsulate orally the key points in response. Grounds 1 and 3 essentially go to the performance of the Council's statutory duty under Regulation 63 of the Habitats Regulations 2017. This being a case where, as your lordships know, the proposed development was considered at least to have the potential to have a significant effect on protected nature conservation sites, and in particular upon the maintenance of their favourable conservation status, and therefore it was necessary to undertake appropriate assessment and to reach a judgment to ascertain whether or not the development could proceed without giving rise to a deterioration in the maintenance of the favourable conservation status of those sites. So that was the issue that was the duty that the council was called upon to discharge, and we've seen a little of how the planning officer who provided the advice on that question, how he went about seeking to understand, to explore, to assess, and to advise on that question. And it's unnecessary to say more on that, on the function of the planning officer's report than this, as this court has said on many occasions, when essentially the decision-making local planning authority acts upon the advice of the local planning officer set out in his report, then the officer's report is to be taken as essentially the rationale for and the reason to give the reasons for the authority's decision. So I proceed on that basis and focus in a moment on what the planning officer said in his report in relevant parts. But before we come to that, there has been some debate as to the nature of the statutory duty under Regulation 63 and as to the legal framework against which that duty is to be fulfilled, particularly in the light of the recent decision of the European Court in the Dutch Nitrate case. Yeah. I ought to just say to this court what my argument is in relation to that question.
Yeah. Just as a matter of interest, though, I think we've assumed it. Has paragraph 101 of the judgment in the Dutch nitrogen case been considered at this level in our jurisdiction, or not?
It hasn't, as far as I know.
No.
Mr. Elvin
I suppose I should add, or above.
No, I'm not aware of it having been considered at appellate level in the domestic courts. But again, Mr. Elvin may be able to point to something. But for my part, that's my understanding position. I mean, just to anticipate, I don't want to go out of order, but just to anticipate the short submission in relation to the significance of that case. The issue in that case was whether it was in accordance with Article 6.3 of the Habitats Directive for appropriate assessment to be undertaken on the basis of a programmatic approach to agricultural activities, which wholly or in large part obviated the need for case-specific assessment to be carried out, and the reasoning of the European, of both the Advocate General and of the court that you've been shown, is reasoning which goes to, and I think it's fair to say, a general high degree of scepticism on the part of both the Advocate General and the European Court as to whether it was possible properly to discharge the exacting requirements of appropriate assessment under Article 6.3 on a programmatic basis. That, in other words, there needed to be either wholly or in very large part a case-by-case or individual assessment of the proposed programme or project that was under consideration in order to discharge and fulfil properly the requirements of Article 6.3. I'll take you to one or two references as briefly as I may in a moment, but that's the essential. And you can see straight away, it follows, if I'm right, that case really says nothing useful to this court, because whatever else one may say about Regulation 63, it is founded fundamentally on the need for individual assessment. Each plan or project is to be assessed where the requirements of Regulation 663 are engaged. And if it had been the case, which it wasn't, that in this case a judgment as to the impact of this proposed residential scheme had been based entirely or very largely upon some predetermined programmatic analysis of the way in which relatively small housing developments would affect nature conservation sites in the Solent. This court may well have been looking to guidance from the Dutch nitrogen case, but of course that wasn't the case. There was, on any view here, a case-specific assessment, both by Natural England and indeed by the local authority. The issue is whether, through the lens of Wednesbury, which is the established basis for judicial review of decisions of this kind, whether there is a basis on which this court, well, firstly the court below, but on an appeal this court should intervene in the decision that was made. So the statutory duty, if you'll forgive me, I won't take you to Regulation 63 again, but if I may just remind you, the three relevant paragraphs of Regulation 63 are subparagraph 1, which requires the carrying out of an appropriate assessment. Paragraph 3, which requires consultation with and regard to be by the decision-making body, the competent authority, both to consult with and to have regard to the representations made by the national conservation body for the purposes of carrying out appropriate assessment and for the purposes of making a decision as to whether the scheme should proceed. Of course, the national conservation body is Natural England in this case. And the third paragraph is paragraph 5, which requires ascertainment as to whether or not the proposed development will adversely affect the maintenance of the favourable conservation status of the site or sites that are protected, and a decision made in the light of that judgment.
Do you accept that depending on the assessment reached, the outcome may be there is a duty to refuse the application?
Yes, because if the judgment is that if in the given case the competent authority ascertains that there will be, or indeed that there is likely to be, then plainly refusal should follow, subject of course to the operation of Regulation 64,
yes.
which is not engaged in this case ex hypothesi. I would also respectfully adopt the point made by my lord as to the evaluative nature of the performance of the Regulation 63 duty in any case in which it falls to be discharged, and evaluative judgments fall to be made both at the appropriate assessment stage and indeed at the stage of considering whether or not, and if so, what weight to give to the representations and advice of the nature conservation body, Natural England, and thirdly, as to in order to ascertain whether or not adverse consequences are likely to follow. Evaluation and, to use a phrase that is commonly deployed in this field of law, multifactorial considerations. We are here dealing with matters which involve often quite technical and scientific considerations, which this court has on a number of occasions indicated are first and foremost for the appointed statutory body to consider. Parliament has taken the view that local planning authorities in the development management context are able to fulfil the function of appropriate assessment. They're able to evaluate the guidance and advice they receive from Natural England, and they're able to ascertain whether harm will or is likely to flow or not. And this court has also made it clear that Natural England is one of those bodies appointed by statute to fulfil a national consultative role in its field of expertise, which is entitled to, I think the phrase has been used in the BACI case, a margin of appreciation. And so insofar as there is an attack directly on Natural England's own guidance and advice, and this court is being called upon to supervise the legality of that advice or the process under which it has been produced, then that margin of appreciation should on authority be given, certainly insofar as that guidance or advice is concerned with technical or scientific matters.
Mr. Mould, may I, at the risk of interrupting you, but really to flag up a point that Mr. Elvin may want to think about overnight. 2 points really. One is that I may be mistaken, but in the light of answers that Mr. Jones has given this afternoon,
Yes.
I don't understand there to be, in fact, a challenge to the policy issued by Natural England as such. But leaving that, sorry, Mr. Elvin, can I just finish the point?
I wasn't going to interrupt.
Yeah, leaving that aside.
Yes.
No one so far has reminded us, but it may be necessary to look at recent Supreme Court decisions decided last year on what the correct legal approach is in those judicial review cases where there is a challenge to policy on the ground that a policy is unlawful and the law has been refined considerably.
Yes.
In two judgments of the Supreme Court last year, one of them is called BF Eritrea, and there was a parallel one decided on the same day.
Yes.
Now, I don't want to set a hair running. If that's not what this case is about, fine.
Yes.
But to my mind, there is a sort of lingering doubt at the back of my mind about whether there is some suggestion that Natural England's policy is unlawful. If it is, then I think it has to be done by reference to those criteria in the Supreme Court.
On the second point, I had read Natural England's advice note here as being in the nature of technical guidance rather than being in the nature of policy. And in the field of planning, where we are, as your lordship will be very familiar, policy, it's a policy-laden discipline.
Yes.
Whereby policy, and one of the essential features of policy, certainly in the planning context, is that the policy maker seeks through the policy to draw a balance between competing considerations, the need for new housing against the impact on the countryside. As I understand it, Natural England are not seeking to draw that kind of balance in the advice note. What they're seeking to do is to identify a methodology which has a scientifically established basis, which, if properly followed in a way that is sensitive to the facts of the given case, can be relied upon to address those residual uncertainties that are a necessary function of seeking to control and to manage and to avoid nitrogen-rich materials getting into a location which is sensitive to harm as a result of a build-up. It's a guidance note rather than being in the nature of a policy. But my Lord, what I shall do, and I'm sure we all shall do overnight, is just to check the Eritrea case, just to make sure that there isn't anything that we ought to draw to this court's attention.
Yes, that it may not be relevant, in which case fine, and we can be informed of that. But I didn't want there to be a lurking doubt.
No, I understand.
I suppose an associated question is whether there is a statutory basis for the provision of such guidance or not.
I have not looked at that. We will look at that. I don't believe that there is a direct statutory basis for it, but we can certainly check that in relation to the legislation which establishes Natural England's function.
Yeah. I mean, it would fall to be considered in any event as a material consideration.
Most certainly.
When we were in the frame of a planning decision, that's to say here an application for planning permission for residential development being determined by a local planning authority, which is the competent authority, then we're in the frame of section 38(6), and the status of the guidance in that frame is as a material consideration. Is that correct?
Indeed so, and insofar as Regulation 63 is concerned, in my submission, there would be nothing legally offensive about Natural England, as they effectively have done, promulgating technical guidance which local authorities in any given case can draw upon as part of their consideration of Natural England's advice under Regulation 63,
yes.
Paragraph 3.
And there's no statutory requirement to make a decision in accordance with Natural England's guidance.
No, the statutory requirement is to have regard to their representations. That's Regulation 63.
Yeah. By contrast with the statutory presumption or priority for the development plan.
Quite so. Now, the first question, Your Lordship, was whether whether there had been in the pleaded case a direct attack on the guidance. Certainly, I had understood that was the case, and it's in. If one looks at the summary ground, at the statement of facts and grounds, which I have, which is I think in the core bundle at 10.
356 is the summary.
That's very kind. Pages 355 to 6 in the core bundle. Yeah. And as Mr. Elvin reminds me, if you look at the bottom of the page, ground 4 sought to impugn the legality of Natural England's advice note by reference to Article 6, subparagraph 2 of the directive. And ground 5 over the page sought to impugn the Natural England advice note on the grounds that it didn't meet the requirement of required standard of scientific certainty. Now, true it is that the bold expression of ground 5 is expressed to be reliance on the Natural England advice note, but the way in which the argument is then explained is that the note is not capable of being relied on to conclude with required standard of scientific certainty, etc., etc. So, in practice, it's very difficult. One can, well, let me put it this way. The court will, from the way in which that is put, and it's developed in more detail later in the grounds of challenge, but where 383 to 5, I'm told, are the references. But the court will see 381 to 3, I'm told. What the court can see is that in practice, the gravamen of the complaint was that the advice note was irredeemably flawed, and therefore any reliance upon it in the individual decision was bound to be flawed accordingly. And there is therefore really no light between the way in which the grounds is expressed and the actual nature of the attack, which is upon the advice letter.
If I could just follow up your answers to my lords. You said that Natural England sought to identify a methodology which, if properly followed, can be relied upon.
Yes.
Well, that raises the question, what if the guidance is not followed, either because of a mistake, Fareham thinks they're following it, but in fact they aren't, or deliberately they think there's more slack in this guidance than there needs to be, and we can, in Mr Jones's phrase, rob a bit of Peter to pay Paul.
Well, then,
now, what's the position then? You said, in answer to my lord, there is no requirement to make a decision in accordance with the guidance. I'm just wondering how all this fits together as a novice in this field.
Because the decision maker in any given case is not obliged to follow the guidance to the letter, it is in principle open to the decision maker to take a different course. The question for the court will be, in taking that course, has the decision maker acted in a way that is challengeable on Wednesbury grounds? It may be, for example, that it is said that the guidance ought ordinarily to be followed, and if the decision maker chooses to act flat contrary to an important element of it, but it doesn't attempt to give any sort of explanation as to why that is, and as a result appears to be adopting an approach which is questionable in the context of, read in the context of Regulation 63, that provides at least an arguable basis for to intervene, because a most material consideration has not been followed, has not been properly taken into account. It may be that the decision maker will say there are other factors in this case that merit taking, starting with the guidance, but then ending at a different point. So the guidance is followed up to a point, but then other factors are taken into account. Again, in principle, that approach would be open to the competent authority, because competent authority is ultimately the arbiter of appropriate assessment, the arbiter of whether there is or is not the likelihood of harm, but it may have to explain itself in coming to that decision. To pick up on a point that my lord raised in argument with my learned friend in relation to the buffer, that the guidance note undoubtedly conceives of the buffer as being applied at the final stage in the computation of the nutrient budget, in order to give a further measure of comfort or precaution as to a practical level of certainty. And as Mr. Justice J pointed out, intellectually, if that is its function as stated in the advice note, is it inconsistent with that to seek to rely on it at an earlier stage in the analysis, as we see here apparently when we come back to the officer's reasoning, where he placed some weight upon it in order to justify his view that the occupancy rate that he selected was precautionary. But again, it doesn't follow on a Wednesbury analysis that was something that was unlawful. It may be that he took the view that whereas in other respects the populating the budget he could do with a considerable degree of confidence, insofar as there was an expression of concern which was focused upon the occupancy rate, which clearly there was. We've seen that the claimants were concerned about it, and there were others, that he could place some weight upon the function of the buffer, because in this case, not in every case, but in this case, the buffer had a particular function in giving comfort and giving reassurance and precaution in relation to that element which had been the source of particular concern on the facts of this case. Again, viewed through a Wednesbury analysis, essentially I've made my submission. I would submit that he was entitled reasonably to deploy the buffer and to give some weight to it at that stage in the analysis, even if that, if you like, at the level of intellectual purity, wasn't quite how Natural England expressed its function in the advice note. He wasn't bound slavishly to follow their methodology.
I mean, you'll show us how, if at all, that suite of submissions fits into an analysis of those 5 paragraphs of the officer's report, and how we should understand those paragraphs.
I shall.
Particularly the penultimate one, which refers to the buffer.
Yes, yes. I shall certainly do that. But may I come back briefly to the legal framework? And again, I think, if I may, relatively quickly, Regulation 63, those 3 relevant stages, authority is fairly clear and established on the approach to each of those stages. So far as appropriate assessment is concerned, you have the judgment of the Supreme Court in the Champion case, and you have that decision in the authorities bundle at tab 11. And I'll simply draw your attention to the judgment of Lord Carnwath at internal page 3728, paragraph 41.
Yes.
I'm not going to read it out. Your lordships may have read it, but I'll just pause for a moment.
Well, he cites
The Vodensee
Advocate
case.
General Krokotin Vodensee at 107.
The point is, the function, the task of fulfilling the requirement for appropriate assessment falls first and foremost upon the competent authority. It's for their judgment, and this court's function is to supervise the fulfilment of that task in any given case on a Wednesbury basis.
Can paragraph 41 in Lord Carnwath's judgment in Champion be reconciled with paragraph 101 in Dutch Nitrogen?
It can, once you recognise that paragraph 101 in Dutch Nitrogen was written by the court very much in the context of emphasising why the court needed to be able to supervise the fulfilment of the what in domestic law is the Regulation 63 duty on an individual basis. The court needs to be able to say, in the case of this plan or this project, the competent authority has discharged its function. The point that was being emphasised in paragraph 101 was that the more programmatic and the more predetermined is the judgment before one even gets to a specific project or plan, the less able the court is to explore the factual basis on which the assessment has been made in order properly to supervise whether it fulfills the legal requirements in terms of process and substance that come together in domestic terms in the Wednesbury assessment. And I would...
Perhaps you're going to come on to that anyway.
Yes, but my submission is that I see nothing in the Dutch Nitrogen case which itself was decided against the background of a rich body of case law in the CJEU, including most particularly Vodensee. Nothing in that case that suggests that they were consciously making a sea change in the degree of intensity which the supervisory court must bring to bear on the discharge of the article, in European terms, the Article 6.3 duty. in any given case. And it would be have been surprising indeed if that was what that case achieves, as it were. I'll come back to it. So, champion article in relation to Regulation 63.1, the appropriate assessment. In relation to Regulation 63.3, Natural England's advice and representations, you've been shown Smythe, and I also draw attention in my skeleton to your Lordship's decision at first instance in the Prideaux case. And we just look briefly at those two references. Smythe you have seen, it's at tab 10, internal page 1448, 1449, paragraphs 78 to 80, and those three paragraphs do need to be read together. Again, I'm not going to read them out, unless you would like me to.
No, there's no need. In fact, he deals with the relevant standard of review,
which is yes,
which is the Wednesbury standard. He says, which is substantially the same as the relevant standard of review. Quotes of manifest error of assessment, unquote, applied by the Court of Justice in Evans, for example,
and indeed, I think in Vodensey,
and in Vodensey, which he refers to.
And it would be as I say, no suggestion whatsoever that the court in Dutch Nitrate was seeking to make a sea change in that regard. Over the page is a further important point. It's actually the one I had in mind. Forgive me, I should have shown you 83 to 85 before showing you 78 to 80. But 83 to 85 is dealing head on with the role of Natural England as the expert national agency and the weight that should be given ordinarily should be given to the advice that Natural England gives. Yeah. And you'll see in 85 there is in fact a reference to your Lordship's judgment in Prideaux, paragraph 116. You have Prideaux in the bundle. It's at tab 8. I don't need to take you to that reference now.
That was a first instance decision.
Yeah. So where, as in the present case, the local planning authority, through its officer, has firstly guided himself by reference to the Natural England advice, has undertaken appropriate assessment and applied and sought to apply the nutrient neutrality methodology set out in the advice for purposes of discharging the Regulation 63 function, and where he has also sought and received clear advice from Natural England's case officer as to the appropriateness and reliability of the work that has been done to apply the nutrient neutrality methodology. In my submission, the court must approach the significance of that advice in accordance with the established principles set out in Smythe. That is to say, it is entirely unremarkable and indeed to be expected that the planning officer would give considerable weight to Natural England's advice, both in the advice note, but also the advice received on that particular case from Natural England's case officer. And indeed, the corollary to that is that the case of the planning officer would require some clear and cogent reasons for departing from Natural England's advice. Because had he chosen to apart from that advice, and as a result had recommended that the Regulation 63 duty led to the need to refuse planning permission, that judgment would have been subject to very considerable scrutiny by the developer, who would have said, you have been told by Natural England that the advice is relevant and appropriate, and that you have applied it in a way that is appropriate, applying appropriate and reasonable inputs to the variables. But in the face of that, you have nevertheless chosen to take a different course. Comes back to my Lord's question. And there might well have been an appeal, and it might well have been necessary to justify that course. So it's easy to forget that the logic of my learned friend's position has that consequence. And another way of putting it is that if he had chosen to advise his committee to take the course that my learned friend implicitly suggests he should have done in the face of Natural England's advice, the consequence would have been that the committee would have been unable to make a modest but meaningful contribution towards the shortfall in their housing land supply. And that was something that might have weighed considerably with them. So there is a trade-off here in the mind of the planning officer. And this court has said in Smythe that in making that judgment, he should give great weight to the advice of Natural England. And that is, of course, what he did in this case.
What if the advice is conflicting? He's in a difficult position then. I mean, I take it what you're accepting is that to fail to give considerable weight to the opinion of Natural England in the absence of good reason is equivalent to Wednesbury unreasonable. But what then does the planning officer or the competent authority do if on the one hand the formal published advice leads in one direction, but there's an exchange of emails which says, oh well, we don't have any concerns?
Well, there is no conflict in this case, if that is what your lordship is driving at. And I'll show you I'll just look briefly at Natural England's representations in a moment. But in short, in my submission, the advice that Natural England's case officer gave was completely consistent with the advice set out in the advice note. She essentially has said on 2 occasions, I am satisfied with your application of the methodology, provided that you are satisfied on 2 particular matters, and we'll come to those. That advice was actually faithfully reported in the officer's report to the members. So the context in which those 4 paragraphs that I'm going to come to, which you've looked at in some detail today, understandably, the context in which that advice was given was that we have received a clean bill of health here from Natural England on this particular case. And the burden of that, in legal terms, is explained clearly by this court in paragraph 85 of Smythe. So you can understand why, that being the position, the planning officer was looking with some degree of caution at the argument from local people that he should nevertheless take a different course and apply a higher occupancy rate. Lord, the other line of authority which may or may not be directly relevant, but certainly your lordships should be reminded of it, is the line of authority that is illustrated, for example, by the case of the BACI Bedfordshire case, which you have at tab 24.
Do you want us to look at that?
Decision of this court, my Lord, Lord Justice Lindblom, is in the constitution of the court in that case, and at paragraphs 96 to 99 on internal page 470, 471, you'll see reference to, I used the phrase earlier, the margin of appreciation. And you'll see that there's a discussion in those paragraphs under the heading, was the judge wrong to rely on the concept of margin of appreciation? This related to an attack on a permit, an environmental permit that had been issued by Natural England, which was said to have been issued unlawfully. And one of the arguments deployed in response to the claim was that Natural England enjoyed a margin of appreciation in the exercise of its expert scientific judgment. And those paragraphs that I've mentioned refer to established authority, the Mott case in particular, in relation to that concept.
Mr. Bold, obviously I understand, we all understand that general proposition, particularly in the context of what may be technical or scientific matters. But I think, and please don't take this out of turn, if you're going to address the grounds specifically in due course, I think the essential submission that's made against you under ground one is that it's not really a matter of scientific evidence at all. It's just a matter of common sense that a 5-bedroom house is likely to have a higher occupancy rate than a 1-bedroom house, for example. And and furthermore, they say it's just a matter of common sense that Fareham is not the whole country considered in average terms.
Yes.
And so they just say it doesn't add up. That's the Balchid proposition, I think. It's just a failure of basic logic. That's what they say, I think.
Yes, and I understand that, and it is implicit in paragraph 4.18 of Natural England's advice that Natural England understood that perspective, but they considered that they had reasons not to follow that, as you say, that apparently commonsensical approach. And the reasons are encapsulated in the observation that the average national occupancy rate of 2.4 as calculated by the ONS can be consistently applied across all affected areas. It was a point going to consistency of application because, of course, taken as a whole, both across any particular locality, any particular catchment, I think 13 local planning authorities affected by the Solent guidance, a very wide range of sizes, scale of development, 8 houses in this case, in other cases hundreds of houses, many of them very, very small units, 1 or 2 bedroom. And so if one begins to think about that sentence, one can see clearly that what must lie behind it is an analysis of what is appropriate in order to start. It's a starting point. What is an analysis? But it's not just a starting point, if you like, which then demands, in every case, a case-specific, careful analysis. It's clearly intended to be a starting point that in many cases can be relied upon as the end point. That's what it means. And that, of course, is where it ended up in the present case. But so, in my respectful submission, that sentence is, once one begins to think about it, without any need to go to Miss Potts, one begins to think about it, and what must lie behind that. Because one, of course, is entitled to assume that a good deal of thought has gone into this. I mean, it would be idle to proceed on any other basis. It's clear that it does involve a significant degree of science and a significant degree of technical consideration. One statistic taken in isolation is very unlikely necessarily to be reliable in this field.
This was a case, I'm sorry to cut across, but just to come back to the point you were making about this matter of common sense, if I could, just before it slips away, that this was a case in which objections were made to the local planning authority, including on the point about the occupancy rate, including, as I understand the representations made, that this was too low an occupancy rate, it was asserted, because one was dealing with bigger houses.
Yes.
And also that this was Fareham, not somewhere else.
Yes.
I think those points were both made.
They were.
So what cannot be said in this case, and is not said, I think, is that the local planning authority simply overlooked those propositions.
No.
And the judgment formed, right or wrong, rational or irrational, was nevertheless formed in the light of those assertions.
And it's the latter that is this court's inquiry. Yeah. It's not this law. It's not for this court to say, with respect, whether it was right or wrong. It's for this court only to judge whether it was rational or irrational. Precisely because it was, those points were clearly in the planning officer's mind, and he had sought to grapple with them. We'll come to those. I'm going to try and come to those paragraphs before 4:30 because it's important that we make that progress. But there's no. It cannot sensibly be argued that he ignored those points. He had them well in mind, and he sought to grapple with them.
I'm sorry, I cut in, but so I don't want to prevent you completing your answer to my lord.
Yes, and so my answer is what at first blush seems an obvious point of common sense is one that one can, with a fairly limited degree of, with relatively little consideration of what is contained in paragraph 418, one can see that point will almost certainly have been considered. But the concern of Natural England is to give a guidance across the range of authorities within the Solent catchment, which can be applied, as they put it, consistently across all areas, having regard to the manifold scale and types and mixes of housing that are going to come forward. And you might have X number of larger units, but you'll have Y number of smaller units.
Quite.
And consistency. They're seeking to provide an approach which can be applied consistency, recognising, as they do, as your lordship put it to my own friend, in 419, that there is always room for, as they put it, a bespoke approach, where the evidence justifies it. Yeah.
In considering the rationality question, are these factors relevant? First, that 2.4 is critically close to the difference between success and failure. It seems to be accepted that if you apply 2.4, then the development passes, whereas if you move up even only as far as 3, then it's going to fail. And next, that the 2.4 figure is an ONS figure taken from the 2011 census, and there is an equivalent figure available for 4-bedroomed houses calculated on the same basis, average national occupancy,
And 3.
which is available and could be used.
Yes, and it wasn't actually the figure that was put forward, but it could have been found.
No, but it's not difficult to find.
No, I understand. I'm not taking that.
If you think, well, 2.4 looks as if it might be on the low side, what should we go for? You would naturally find.
There's no doubt that it would have been entirely reasonable for the planning officer to take that, to have it gone off and to discovered what the figure was for Fareham for 4-bedroomed houses, and to have said, I think, on balance, I would prefer to advise my planning committee that we should adjust the budget accordingly, and we should require a relatively modest increase in the area of wetland that is provided in order to mitigate. Would have been a perfectly reasonable decision. The question for this court is whether it was Wednesbury unreasonable for him not to have taken that.
Yes, well, I was asking really whether it's relevant in considering that question to have in mind that these figures are so close to the line. I mean, if 2.4 is not really going to make any difference at the end of the day, then one can see that one might not need to get too fussed about it. But if it becomes clear that actually it's quite critical to where this comes out,
but he may I don't think I could persuade you that in principle it's not something that is of relevance, because the closer one gets to the margin, obviously, the more challenging may be the need for some rationalisation. He did give his reasons, but one of the factors that he clearly set against that was that although the proposal was for larger houses, the scheme was relatively modest in scale, and that whilst some of those larger houses no doubt would be more heavily occupied, others not. It would be difficult to argue that those factors equally relevant were somehow irrelevant or irrational. It's what one is doing in this exchange is actually to unpacking the multifactorial evaluative nature of the process, and one might. I mean, there's nothing remarkable either about the degree of reasoning that is given in those 4 paragraphs. It's the degree of analysis that one often finds in decisions of this kind. They don't tend to go into enormously lengthy discussion. Some do, others don't. Some give far less reasoning than this. But the reasoning is to be judged on the basis, as the court knows, on the basis of what it says, and the court will only intervene where there's no basis for intervention on that strand of Wednesbury that says that a relevant factor has been ignored or an irrelevant factor has been taken into account. We're not in that consideration. This isn't that kind of case. This is actually a straight Wednesbury perversity case. And so what the court is being asked to do is to say that reasoning, including those strands the Lordship put to me and I've submitted in response, that reasoning nevertheless can properly be struck down as perverse. My submission, this isn't the case where that judgment is justified. Lord, I said I would go to the Dutch nitrogen case. If I may, I hope this doesn't. This isn't a presumptuous request. Would it be convenient for me to give you some paragraphs?
Yes, it would be. It would be, and you invite us to read those overnight.
Yes, if that would be.
Which will save time overall.
So we're in the small bundle, I think, and if I could invite you to read the head note at page, obviously at the first page of the report, in particular paragraph 3 on page 582, and then the holding, so the head note and paragraph 3 on page 582. Then in the holdings, if you could look at H6 on page 583. And then in the judgment of the court, 199 to 101, and in particular the final sentence of 101, which is where the court emphasises that its concern about the court's supervisory role is its ability to scrutinise the validity of the assessment in relation to, quote, each specific individual project. And then finally, paragraphs 113 to 120, where the court is dealing with the third and fourth questions. That's on pages 637 and 638. And those paragraphs will reveal to the court very clearly that the context in which this decision arose was concern on the part of the referring court about whether it was proper to seek to discharge the Article 6.3 duty of appropriate assessment, etc., on a programmatic rather than a case-specific basis. I think Mr. Elvin may also want you to read 126. Yes, may as well get his references in as well. So I think it was 126 to 130, wasn't it?
It's, yes, 126 to 130.
Yeah, that's on pages 639.
Yeah, well, that deals with the issue of certainty, but shows you very clearly it's because the programmatic scheme procedurally didn't assess the measures until some unknown future date. So it was specific to that particular case.
Now, in the last 5 or 6 minutes, may I just take you to the the Natural England representations and also, if time allows, to the officer's report. First, as you're in the supplementary bundle, the first Natural England response in time was that of the is at tab 5, 74 to 76, 9th of June 2020. And under the heading Nutrient Neutrality, further information required, you can see, if I just invite you to read the first 3 paragraphs with regard to down to the end of the paragraph, which begins provided the measures. Just those few lines. And then if you would turn back to page 72. This was the final response the day before the committee met on the 18th of August 2020 under the heading Deterioration of Water Environment. Again, the first those three paragraphs at the bottom of page 72, if I may, which, as you will see, are in very similar terms to the earlier response.
And we haven't got the questions to which these are a response.
These are, there would have been a consultation by the planning officer. He would have got in touch with Rachel Jones, who is the Natural England case officer, and she would have been provided with details of the planning application, and she would have been asked, and indeed the nutrient budget calculation provided by the developer, which you've seen at the back of this file, and she would have been asked for her comments in accordance with Regulation 63, subparagraph 3 of the regulations. So she would have been writing these comments in the knowledge of what was proposed and of the nutrient budget. You can see
so she might have picked up that this was for 4 to 5 bedroom houses.
She would undoubtedly have picked that up because she would have seen the calculations. And indeed, she had received, if you look at page 77, this is a letter from Rachel Jones, the case officer, on the 16th of March 2020 to the developer, commenting on his proposal to seek to address the risk of nitrogen pollution of the Solent arising from the development in accordance with the guidance given by the Natural England Advice Note. The wetland proposal was his selected solution. So she was, it is inconceivable that she was not properly appraised of the factual position. And she as you have seen from page 72, for example, she raised no concerns with regard to the nutrient budget, provided that 2 particular matters were assured to the competent authority: the site areas used in the calculation of collect, and that the existing land uses are appropriately precautionary. She had no concerns about the use of the 2.4 occupancy rate. She had no concerns about the deployment of the precautionary buffer, and she had no concerns about the allocation of nitrogen produced by existing land uses on the basis of the farm scoper model. Although she wanted the existing uses to be checked, that was about the fact of what the land had been used for, rather than the attribution of nitrogen generation from those uses on the basis of the Farnscaper model. And that advice is then relayed to the Local Planning Authorities Committee in the report at page 226 under section 7, consultations, 7.1, 7.2, 7.3. So the committee proceeded in the knowledge that that Natural England's case officer was satisfied with the deployment of the occupancy rate 2.4 in this case, with the deployment of the Farnscaper model, and with the deployment of the precautionary buffer. See Smythe, considerable weight to be given to that advice. Lord, I haven't got it quite to where I wanted to. I wanted to show you to go back to the reasoning, but if I can go back to that first thing tomorrow. Of course, I don't propose really to say anything very much at all about grounds 2 and 3. I've dealt with them fairly briefly in the skeleton. On ground 4, my lord said, "Isn't this really about the final sentence of paragraph 8.83?"
Well, some submissions were made on that, which I think you will need to.
I will deal with those.
Deal with.
Yes. But I'm assuming that the court will not need me to go through what I've said in my skeleton.
No, and you won't need to do that any more than anyone else would need to go through the skeleton arguments. But I think you should address the points that have been made on ground 4.
I will do so. Yeah.
Today. Right, so we'll start again then at 10:30 in the morning. Thank you all very much.
Court rise.